Can someone be convicted of murder even if they never wanted the victim to die? The answer lies in one of the most important criminal law decisions ever handed down. R. v. Woollin. Every criminal offence requires two essential elements: actus reus, the guilty act, and mens rea, the guilty mind. Murder, in English law, strictly requires an intention to kill or cause grievous bodily harm. But what happens when death was not the defendant's purpose, yet they knew it was almost inevitable? This brings us to oblique intention, where a consequence is foreseen rather than directly desired. Let's trace the historical timeline of virtual certainty, starting with the controversial 1975 case of Hyam. Here, the House of Lords suggested that foresight of a highly probable consequence could amount to intention. But this created deep uncertainty in English courts, confusing mere foresight with actual criminal intent. This led to the 1985 case of Moloney, where Lord Bridge completely rejected the Hyam approach. He ruled that foresight is evidence from which intention may be inferred. But foresight itself is not intention. Then, the 1986 case of Hancock and Shankland introduced a key probabilistic test for juries. They held that the greater the probability that a consequence would occur, the stronger the evidence of intention. Later that same year, the Court of Appeal in Nedrick finally introduced the famous virtual certainty test. The jury may find intention only if death or serious bodily harm was a virtual certainty, and if the defendant appreciated that consequence as virtually certain. This became the foundation of modern law. Now let's examine the tragic facts of Woollin, which ultimately tested and solidified this rule. A father became frustrated with his crying 3-month-old son and threw him toward a pram. The child missed the pram, struck a hard surface, and tragically suffered fatal head injuries. The central legal issue was, did the father actually intend to kill or seriously injure his child? In the landmark judgment, Lord Steyne approved the Nedrick direction, with one extremely important refinement. He ruled that a jury is not entitled to find intention unless two criteria are met. First, death or serious bodily harm must have been a virtual certainty as a result. And second, the defendant must have appreciated that consequence as a virtual certainty. Critically, Lord Steyne emphasised that virtual certainty does not automatically equal intention. Instead, it merely provides strong evidence from which the jury is permitted to find intention. This crucial distinction successfully preserves the jury's historic role in deciding criminal intent. Let's apply this to a practical example. A defendant sets fire to an occupied house. Their sole purpose is to destroy incriminating evidence, but they know someone remains inside. Because they know someone is inside, death is virtually certain to occur. Would Woollin apply? Yes. If the jury concludes death was virtually certain and the defendant appreciated this, they may find intention. Let's review common student mistakes in exams to ensure you avoid these typical traps. Do not confuse foresight with intention, and do not assume virtual certainty automatically proves intention. Also, never forget that subjective appreciation by the defendant must be proven beyond reasonable doubt. And lastly, do not ignore the jury's final discretion to decide if intention actually existed. Remember, Woollin does not redefine intention. It provides guidance on when a jury may find it. Here are the key takeaways. Woollin is the leading authority on oblique intention in English law. It refined the Nedrick direction, establishing virtual certainty as an essential evidential test. The defendant must appreciate the consequence, and the jury may choose to find intention. For exams, always remember this exact chronological sequence. Hyam to Moloney to Hancock and Shankland, leading to Nedrick, and finally R.V. Woollin. Memorising this progression is absolutely essential. Understanding this is vital for answering problem questions on intention in murder. If you're preparing for your LLB or SQE exams, subscribe to Lexi Transcribe for clear, exam-focused explanations. Visit our website for more expert legal breakdowns of the landmark cases that matter most.